Hello, my name is Grant McDonnell, and I'm presenting on my honors capstone project for this semester, which was a policy solution for protecting personally identifiable information, or PII, on the RU cloud. This is especially relevant because recently RU transferred many of its services onto a cloud-based system. And so this will be very important to implement going forward. To go over what we'll be discussing, we'll be talking about the risks to PII confidentiality from the perspective of a cloud user, cloud providers, how they use safe harbor laws and policy to avoid legal trouble, and governmental efforts to mitigate the use of safe harbor policy as well. And we'll also be discussing court decisions related to PII cases, the development of the legal precedent, which is often cited in PII related cases, and how that precedent affects cloud users, as well as a potential solution to the lack of PII protections on the cloud using policy at the lower level, like in universities and other institutions. So the main problem going into this project is the safety of cloud users' PII is not ensured, and they do not have consistent means of restitution when their personal information is compromised. Cloud service users inherently risk their PII by choosing to store it on the cloud, whether that's on Google's cloud or Microsoft Azure or anything. If you store your personal information on the cloud, there is a risk that it can be exposed or distributed without your consent, because oftentimes there are automated algorithms that take your personal data and distribute it out to whoever asks for it, really, without your consent or without your approval. And so that's one way that your PII can be exposed, or if there's just a bad actor who is able to enter into the system of a cloud provider, they'll be able to steal and expose your PII that way as well. So compromised personal data can lead to many other insecurities, such as identity theft, inference attacks, as well as monetary time and other resources lost. Cloud users, in order to gain restitution for these things that they lost, usually must do this by creating class action lawsuits, because trying to sue a cloud provider for losing your personal data by yourself is very expensive and time consuming. And so class action lawsuits are normally necessary to consolidate resources and to get lawyers to give them an incentive to want to support you on your case. So what is a safe harbor policy? It was introduced to larger businesses through the Sarbanes-Oxley Act in 2002, as well as other Know Your Customer or KYC policies, to make companies exempt from legal liability and damages if they meet certain requirements when an infringement is committed against the company. And cloud service providers make use of safe harbor policies by, cloud providers make use of safe harbor policies to sidestep the legal responsibility to provide adequate data safety measures and like to follow security standards and that kind of thing. So laws such as the Digital Millennium Copyright Act and FERPA, which protects student data, as well as EU laws like the GDPR and state laws like the Virginia CDPA and the California CPA, were created to protect data privacy and try to mitigate the use of safe harbor, make it give more specific requirements under which companies are able to use safe harbor. But unfortunately, these laws have not been very effective in mitigating the amount of times that safe harbor is cited. So some court court decisions that are related to PII cases. The main legal precedent that was or that is used in PII cases is one that was created through the case Kirchner v. Obama in 2009, and the precedent is the injury in fact precedent, which was expanded upon in the 2016 case Spokio Incorporated v. Robbins, and which expanded upon that by saying that plaintiffs must provide a concrete injury in fact. So basically, somebody who loses their data or their personally identifiable information due to a cyber attack or other means must provide ample evidence that that specific cyber attack was what caused them to lose their data and not any other incident. And so this makes it very difficult for plaintiffs to prove that they lost their data to a specific event in a court of law. I looked at 15 different civil cases relating to PII, and of those 15, only 6 had no charges dropped due to the use of the injury in fact legal precedent. So what we've gone over so far, safe harbor policy keeps cloud users from suing for damages from data breaches or from their personal information being leaked. And even if a case is made against a cloud provider, plaintiffs will likely not be compensated after their PII is stolen due to the difficulty of proving the claims that they make in court. And other universities and smaller institutions have created their own PII policy to kind of give their users and their customers more rights as early as 2010, such as with Jefferson Community College in New York and UC Santa Cruz in California. So my solution to this issue is that Radford University should update its own technology policy to give more rights to customers using the cloud and protect data from breaches and from unauthorized distribution. We should also make efforts to educate administrators and students as well about PII safety to keep them from putting their PII on the cloud where it can be at risk of being leaked. We should also make sure that we consistently update this policy as the general environment of cloud safety at the higher levels changes as well to reflect what the current state of the cloud environment is. Thank you. Are there any questions?
Put that slide back up.
Yes.
Excellent job, Grant.
Thank you.
So basically what you're telling me is that organizations are putting my PII out in the cloud, and if it gets hacked, there's really not a whole lot I can do about it.
Yes, that's what I'm saying.
That's what I thought.
We have one comment from Noah saying that the cloud providers are typically able to skirt past these lawsuits by making customers sign a document stating that the shared responsibility model makes it their responsibility to protect their data, that the cloud providers are only there for infrastructure. So once again, the wonderful user agreement works more for the cloud provider than it does for the individual.
There's really not a lot of protection. Once you put your data on the cloud and you sign that agreement, the company who's managing your data basically says, we're not responsible for keeping your data safe, which is not a good practice in my opinion.
Exactly. We need to move on. I have one more question for Grant, Blake, and Key. Will you guys get set up? And Grant, we have a question from Bobby. Safe harbor appears to be more about securing the data. Does it address the privacy aspect? That is where many of these issues happen. Is that where many of these issues happen?
So securing the data is an important part of keeping the data private. And so normally safe harbor policies are used when somebody commits an infringement against the cloud provider. So that might be that's like whether a user of the cloud services whose data is stored on the cloud is doing something illegal, or whether that's an outside actor such as a hacker or whatever. Not sure if that actually answered the question.
Okay, well, thank you very much. This was a very good project. You've learned a lot, and I appreciate your sharing your insights with all of us.